Yeah, I'm just starting the recording. Okay.
Good, thank you.
This PTR is in the matter of case number CFI 044-2021 and is being held by way of video conference before Justice Wayne Martin. Any orders or directions made during or after the course of this hearing will be issued by the registry on the judge's instructions. The claimant is represented by Charles Russell Speechless, LLP. Lead counsel is Mr. James Beckford Smith. The defendant is represented by Adilshaw Goddard, Middle East LLP, and the lead counsel is Mr. Mohindirpal Sethi Casey.
Good, thank you. Right, gentlemen, who'd like to go first? Mr. Beckford Smith.
Good evening, Judge. Good evening, Your Honour. This is a pre-trial review in a long-standing matter, which is now set down for trial over 10 days in February. One point I should make at the outset is that Your Honour will not have before him a bundle containing extensive applications, correspondence, etc. The reason for that is that there's been a good measure of cooperation between the parties in the run-up to this hearing, and in fact the issues between the court are so minor that it was felt appropriate simply to use the court file. There will be a couple, and it is literally a couple of documents to which I will take the court as I briefly go through things.
Yes, certainly.
The first document I should go to is the pre-trial checklist of the claimant.
Yes, I've seen that.
To go through this briefly, the position is as follows. Trial bundles will be completed in early February, by the 5th of February, as ordered in the consent orders. There are no orders for interpreters or experts. The one point that I should draw attention to is at paragraph 7 of this, with regards to time estimate. Now, an effect of the various consent orders made has been that we only had reply evidence filed on Friday. And for that reason, the claimant was felt the appropriate thing to do was to liaise on trial timetable and as such estimate with the defendant after this PTR.
All right. Sorry, just let me turn that off. Sorry, yeah, and I think that was because the reply evidence, the defendant's reply evidence hadn't been put on. Is that right? Is that still the position, Mr. Sethi?
It's both sides' reply evidence, Judge.
Oh, I see. I saw one statement from, I saw a statement from the claimant, from Mr. Mahmood. There are other statements to come, are there?
Yes.
Yes, all right. And Mr. Beckford Smith, are the statements on your side to come?
No, there is no statement, and I should say that I have seen the defendant's 2 extra statements. They may not be on the court file, but
you've seen, all right. They haven't found their way to the court file then yet. All right. So you will confer in relation to trial time?
Yes,
that's correct.
All right. Now, am I right in thinking that the only result of that conferral would be that trial time might reduce rather than increase? Is that?
That was the position a while ago. It is no longer the position as I understand it to be. That is because there are 2 statements for the claimant, both of which are fairly substantial, and then there are 9 witness statements from the defendant, and a further 2, albeit I think one of the 2, I believe I'm right in saying, is very short. So in those circumstances, I don't consider the trial timetable likely to reduce.
All right. Well, if it's thought that more time is needed, that would be difficult for me because I have commitments the following week. So if more time is required, we might have to think about sitting longer hours, or possibly there's an intervening weekend, so we could possibly make use of that if we have to. But we have got 2 weeks set aside. I would have thought that should be enough time, wouldn't it?
Yes, and from the claimant's perspective, this is a long-standing matter which he is keen to bring on and have resolved. That is the one issue with reference to the weekend. The one issue I potentially foresee is about closing submissions and when they are done. But in terms of is the time estimate ample for the evidence in the case, I will confer and take instructions from my client and those instructing me. But 10 days is quite a long time.
Yes, that's my feeling too. And if need be, if we can't do closing submissions in the course of that 10 days, we could always do them by video sometime after.
Yes.
On the basis of substantial written closings followed by hopefully shorter oral closings.
Yes, that I would be content to take that approach, especially the one thing I would be uneasy about is purely written closings.
Yes.
I'm against that. And the only other outstanding agenda item is that in the defendant's trial checklist, they have appended a statement of costs for preparing the amended defence. I may leave Mr. Sethi, King's Counsel, to address that and then reply. I think that may be the best way to do that.
Yes, all right. Thank you, Mr. Bickford-Smith. Mr. Sethi.
Yes, Judge, thank you very much. On trial time estimate, I think the 10 days appears to be adequate at the moment.
Yes, good.
So I don't need to address you further on that.
But I'd like to, don't get me wrong, I'd like to try and do oral closings if we can within that 10 days. But if we can't,
yes,
then that may be a way of finding some extra time.
I think we should all be aiming for oral closings within the 10 days.
Yes, I agree.
Secondly, in terms of the defendant's costs of settling the amended defence, Judge, there is the order of His Excellency Justice Maha Al-Mehri, which you may have seen, dated the 9th of September 2022 on the court file.
Just pull that up. Yes.
It's the order dated, sealed on the 9th of September 2022.
The system's thrown me out for the moment. Anyway, tell me about it, Mr. Sethi.
Simply that paragraph 5 of that order said that by no later than the 8th of December, the defendant shall file and serve its amended defence, and that the issue of the defendant's costs of amending its defence shall be reserved to the trial judge for determination at the pre-trial review. Right. And that's why we've served our schedule of costs of amending the defence. It will not have escaped, Judge, your attention that extensive amendments were made to the particulars of claim, requiring quite extensive amendments to the defence. You have a defendant's schedule of costs, I hope, before you.
Yeah. Well, I haven't actually seen that. When was that filed?
I'll just take instructions. At the middle of last week, I'm told, on the system.
Well, is that on the 7th of December, perhaps?
We're just checking the exact date.
No, it's not on the file that I've got. Look, to cut a long story short, I hadn't had any notice of this issue. Is there any needs, aside from the order of Justice Al-Mehri, is there any reason that this matter needs to be dealt with now? Couldn't we deal with it in the course of the trial when I'd be much more familiar with the issues?
That would be
sorry.
Yeah.
Yes, Mr. Bickford-Smith, I take it the costs are disputed, are they?
Yes, that's right. I mean, it's not a sort of, I don't want to, I'm not going to claim it would take me hours to deal with it. It's a short schedule. No. But my point on this is I of course understand the order that was made, but it does seem to me much more logical for Your Honour to determine this with a more detailed understanding of the matter at trial. But that's my first submission on it.
Yes. Mr. Sethi?
I have no difficulty with that whatsoever, Judge.
All right, good. All right. Well, let's stand that over, and that can be on the agenda when you perhaps we'll come back to that after you gentlemen have finished opening on the trial. We can work out when a convenient time to deal with it would be.
Yes.
Yes.
Uh,
Right.
thirdly,
Anything
Judge,
else, Mr. Sethi?
Yes. Thirdly, in our pre-trial review checklist, you'll have seen at item 6, we just formally seek the court's permission for 3 of our witnesses. We've got 9 witnesses in total,
Yes.
6 of whom are appearing in person, but 3 of whom we propose to give evidence remotely. Now,
Yes. Mr. Bick, yeah.
I'm not sure if it's if Mr. Bickford-Smith
Well, is there
has
any objection, Mr. Bickford-Smith?
Just to one of them.
Right.
My
Which one?
apologies. It's the first of all, as regards the 2 we are not objecting to, namely we are not objecting to remote evidence from Mr. Bucket or from Mr. Phoebe. In saying that, I do assume the defendants are obviously represented by Adelshaw Goddard, who are an international firm. I do assume that Adelshaw Goddard will make appropriate arrangements for the witnesses to give evidence remotely from, for example, one of their offices or somewhere where the court can be, happy that that's all proceeding.
Yes.
The one,
and on that subject, they'll have access to all necessary documents too, I assume, Mr. Sethi, wherever they are.
Yes, indeed.
Yes. All right. Thank you.
So,
Mr. Bickford-Smith.
the one individual who there is really an unease about attending remotely is Mahmood Mahboob. Now, this is, I'm not going to take the court through his statement, which I have, sorry, a flourish of notes, as you can probably see on camera,
Yeah.
but this is a substantial statement. It's 48 pages long, and there is, I'm afraid, likely to be a very significant contention between Mr. Mahmood and the claimant's side, and the cross-examination on this is going to be significant. And I do have to say I have a slight unease about conducting this remotely. There are some very strong statements made in this about the claimant and his conduct and his dealings with Mr. Mahboob during the review undertaken by Mr. Mahboob, review/investigation/appeal. And I do have to say that the cross-examination, to use a simple word, is going to be very contentious. Now, that is, if and insofar as the court is content to proceed to make findings on the basis of such a cross-examination, that is not something to which I would object. But if the court feels that if strong allegations are being put to someone, they should be in person, then I would ask that he attend.
Mr. Sethi, what is there a reason why Mr. Mahboob can't appear in person?
A number of points simply arise from this. He's based in Hong Kong. His evidence, I'm surprised that my learned friend's submission is that cross-examination of him will be contentious. Well, cross-examination of any witness is usually contentious. He will largely speak, in fact, exclusively speak to the contents of an investigation, a report of his own. So his evidence is largely contemporaneous and in writing. I don't see any particular reason why he needs to attend in person. I should also add that all of our witnesses had been preparing until very recently on the basis that this was going to be a remote trial because of the directions given by the court. It was only until the 9th of November that for the first time the court indicated that it would be in person. There are issues of costs as well in terms of him having to travel over from Hong Kong. And we think it's simply disproportionate. He's not a protagonist. He's one of the lesser witnesses. And as I say, his evidence largely will speak for itself in the form of his written contemporaneous reporting. So I remain unconvinced as to why we should expend the disproportionate sums in getting him over. Any witness that comes over for this trial will need to come over for 5 days minimum. And that's the problem as well. So unless there are some compelling reasons, some good reasons, then we would strongly urge you, Judge, to permit him to give his evidence remotely. We've made arrangements along those lines, and there seems to be no good reason to require otherwise.
Well,
just
Mr.
coming.
Beck, yes.
Just, I'm not going to repeat what I said, but I am going to come back on one point. The suggestion that Mr. Mahmood is mainly speaking to an investigatory report, and that in a sense this is all about the construction of what is written. That is, in my submission, incorrect, respectfully, because at paragraph 67 of his statement, he refers to a call that occurred between him and Ms. Al-Najjar. About and I mean, the tenor of this I think I can give by 67A. I attended a call with Ms. Najjar, which I can summarize as follows. Ms. Al-Najjar explained that the claimant had a history of raising complaints and the defendant had undertaken 4 or 5 separate investigations, etc. So there's no dispute but that there was a call between these two individuals in which, to put it mildly, a pejorative account of the claimant and the history of this matter was given to Mr. Mahmood. And so the question is going to be whether, in fact, that call, among other things, rendered the investigation which followed something of a going through the motions. Now, that's a case that may be put to him. If the court is happy for that case to be put remotely, I am not dying in a ditch over this. I simply felt it appropriate to mention the point. As regards cross-examination being contentious, that is agreed and indeed axiomatic.
Yes, well, Mr. Bickford-Smith, it sounds as if your concern was really for my sensitivities. We've all had, well, first of all, in a country as big as Australia, we've had a lot of experience of cross-examination of witnesses remotely anyway, to avoid them travelling very large distances. But of course, during the pandemic, we all got lots of exposure to evidence given virtually. And I've actually found, indeed, just to digress for a minute, I sat in a lengthy hearing in another city in Australia where the witness was in the room to the side of the tribunal. But because there were other participants virtually, we had a screen in front of us where we could see the witness on the screen. It was actually a lot easier to see the witness on the screen than it was by looking at the witness in person. So, and you actually get a better view sometimes on the screen than you do in a hearing room. So I have no qualms about making credit findings on the basis of witnesses giving their evidence virtually. And I have to say, again, my experience in commercial cases is that it's very rare that any credibility findings properly turn on demeanour. The credibility findings are most properly based upon inconsistencies in the oral testimony with either the objective facts established by other evidence or inherent implausibility. Demeanour is a very unreliable guide, I find, especially when one sits in an international court like this one, where they often have witnesses from different cultures, and we are very bad at assessing demeanour from people, from other cultures, because we just don't understand it. So for all those reasons, I don't feel that there'll be any prejudice as a result of that witness giving their evidence virtually. And so I'll make the orders sought by Mr. Sethi. Is there anything else, gentlemen?
No, Judge, not from me. Thank you.
All right.
Nor from me.
All right. Well, I wonder if you would confer in relation to trial time and just confirm with the court that 10 days will be adequate. If it isn't adequate, I don't know what we'd do. But if you could just confirm that 10 days will be adequate. And again, if you could confer amongst yourselves in relation to a tentative schedule allocating those 10 days, that would be very helpful, I think. So if you'd allocate some time for oral openings and then the order of witnesses and approximate estimates of time for cross-examination, that would be very helpful, I think. All right, well, if there's nothing else, thank you very much both for your time, and I look forward to seeing you both in February in Dubai. All right.
Thank you very much.
Grateful.
Good day.
Bye.